just a few minutes to join us. We're sorry for the delay. We are sitting in the church center in the UN, at the UN, and our internet went out. So we had to scramble in order to get online so that we could join you. And I'm sitting with Muthia because my computer wasn't able to get a stable connection. But we're doing the best we can. So thanks to Muthia and Mads and our team for working with us. We're really delighted to have you May 2026 meeting. We're delighted about the program and we welcome you. We know that things are getting, things are becoming increasingly challenging. And we know that we have a lot of work to do in order to continue to strive to make the world a better place for women and girls. And I think that this program that we're going to have today is going to point that out to you. But without further ado, I'm going to turn the floor over to my co-chair, Rosa Lazard.
Good morning, good afternoon, good evening. Buenos días, buenas tardes, buenas noches, bonjour, welcome to everyone. It's great to be with folks today from a very, very hot New York City. I hope everyone's doing well. It's great to connect. I'm going to be providing some updates. The first update is around the NGO CSW NY involvement in the Women Deliver Conference that took place the last week of April in NARM in Melbourne, Australia. One of our main contributions was through the Act Against Violence Against Women and Gender-Based Violence Strategy and Communications Advocacy Group, of which we're a member, with the accelerator, the coordinating body for ACT, the working group, the accelerator for gender-based violence prevention. On April 26th, one day before the Women Deliver Conference, we organized a pre-conference day on gender-based violence. It was co-hosted by the Accelerator, by Me Too, by Freeform, Justice for Migrants, and the Equality Institute. It was a very successful full day of events highlighting gender-based violence issues, solutions, and it also featured participation and a session by Pacific Islander women, of which there were many, many, many at the Women Deliver Conference, and local Aboriginal women participation as well. So we want to highlight that one. The report of that is still being finalized and we will share with you. We also participated with the accelerator on a strategic foresight for a violence-free future. This was primarily an exercise of being able to foresight or vision different scenarios regarding gender-based violence, the good, the good, bad, the bad, good, and the bad, bad. And that type of visioning, together working with a leader from the feminist futurists, helped us, in a sense, plan for the worst, plan for the best in terms of gender-based violence. And we will also be providing any information coming out of that session. It was an interactive session, so we have highlights of it that we can share with you. I also want to provide some updates on the UN80 reform. As you know, and many of you are involved in that. We had a briefing during the second week of the CSW with Guy Ryder, the Undersecretary General, who has been commissioned by the Secretary General to be in charge of the UN80 reform overall. Primarily, we're looking at the proposal for the strategic merger of UNFPA and UN Women. So just in terms of our due diligence, we are keeping tabs with the issues around this UN80, primarily the proposal for the merger. In NARM in Australia, I was part of a meeting with the Deputy Secretary General Amina Mohammed and members of the feminist movement and participants from the Women Deliver Conference in NARM. That meeting was the second of what I think there are three now meetings with the Deputy Secretary General and members of the feminist movement, civil society. In that meeting, there were a lot of sharing of information. There wasn't a whole lot of time for deep clarification, but these are ongoing meetings that we want to let you know about. As many of you know, the strategic merger assessment was released in April 24th. This is the final consolidated report. I could put that link in the chat. And on April 30th, the DSG, alongside Sima Bahous, the Executive Director of UN Women, and Diana Keita, the Executive Director of UNFPA, presented the assessment to permanent representatives of member states on the board of UNFPA and UN Women. This is during a closed meeting. And that report of that meeting we do not have access to. We understand that a number of member states had to raise questions there, raise concerns about the proposal. And there was also a broader General Assembly briefing on the UN80 initiative on the 29th of April. And there is a link I can put for the UN Web TV in the chat. I know many of you are part of this effort. If you want to provide updates in the chat, we know that this is an ongoing process. We know that currently member states are reviewing this assessment and that there are meetings that are going to be planned for in the next month, particularly around the HLPF. So we wanted to keep you abreast of this issue and ensure that we're able to provide any information that we come across. I also want to ask for those who were at the Women Deliver Conference and participated in any of these sessions to please put your inputs in the chat, and I'll be reviewing them after this update. So I want to pass over now to Marlene McLean, who is one of the co-chairs of the Advocacy Research Group, along with Ivy Cook, who will be providing an update on the ARG, as it is known by its acronym. So, Marlene, if we can highlight Marlene here.
It looks like Marlene has not joined the
update.
meeting yet. Marlene and Ivy have not joined yet.
Okay, I'm not seeing Marlene. So, is Ivy here? Either Marlene or Ivy, if they can be highlighted.
Rosa Mad said that neither one of them has joined the meeting yet.
Okay. So we'll come back to this. Thanks everyone for bearing with us on trying to highlight Marlene. Marlene, can you turn on your camera and it will be easier to find you and to feature you? We can't feature anyone unless, oh, there you are. Wonderful.
Good morning,
Thank
everyone.
you.
Good morning. Sorry for being tardy. I'm just joining.
Great. The floor is yours if you want to give an update on the ARG.
Okay. This year, we want to do things a little differently. Instead of just the committee submitting recommendations, we're opening the floor and asking everyone if they have recommendations they would like us to highlight. It needs to be a short submission, and we would like it to be, and I don't have my notes with me, but I believe we're asking for about 500 words or less. And it's something that opens the recommendations to more people, not just the same select few people on the committee. And the priority themes are the SDGs. So you decide which SDG you would like to highlight and send us your recommendations. And we're also including in the, I guess the group, we're asking the young people, the YLYP committee, to join with us and work on these recommendations. We don't want the young people to just be an addition at the end of the recommendation. We would like their actual recommendations and suggestions from early in the process. And I think that's it.
Thank you so much, Marlene. Much appreciated. All this information will go out in our newsletter so that you know the specifics of the next stage of the ARG. And I'm so glad you will be starting early. I am going to turn the meeting over to my co-chair, Pamela, who will introduce the fantastic program that we have for today. Thank you all.
Thank you, Rosa and Marlene, for those updates. So we want to introduce our program, Gender Justice Now, Why the Crimes Against Humanity Must Be Feminist. This is a critically important program that we are bringing to you today. And for those of you who attended the CSW forums briefings, Ndai Sahur will be a familiar face for you. She is a fearless activist, a women's human rights defender, and she is the convener of the Women's International War Crimes Tribunal on Japan's military sexual slavery. She has worked in over 90 countries doing the work necessary to protect women. So we are grateful to have her guiding this important conversation. And this program is going to inform you about the important work initiating an effort to bring civil society together to ensure that we hold our governments accountable for the next 3 years to codify crimes against women and the Crimes Against Humanity Treaty. So we're going to look at the history, what the treaty is, how did we get here? We're going to look at what's at stake. We're going to learn about implementation internationally, nationally, regionally, and on the ground where our work happens. And then we're going to look at the importance of having a monitoring mechanism that can actually be used to hold member states accountable. So with this overview, I'm going to turn the program over to Indai and our prestigious panelists. We are delighted and honored to have the five of you here. And with gratitude, I turn the floor over to you. Thank you.
Thank you so much, Pamela. First, I would like to thank again Pamela, Rosa, and the members of the NGO CSW Executive Committee for establishing the Working Group on Crime Against Humanity. Thank you for really ensuring that the global women's networks are aware of the Crime Against Humanity Treaty being drafted and fought for at the United Nations today. At the CSW this March, Pamela and I and Rosa, we realized that most of the women didn't actually know about the Crime Against Humanity Treaty. And because of that, this is the reason why they set up the Working Group on Crime Against Humanity Treaty and why we are organizing this webinar. Now, in this session, we will discuss the significance of the Crime Against Humanity Treaty, which cannot be overstated for us women globally. But before we go into the importance of the Crimes Against Humanity Treaty, which my expert colleagues will discuss, allow me to step back a little bit into history. In 1996, a group of feminist activists established the Women's Caucus for Gender Justice, and we have one ambitious goal: to influence the drafting of the statutes of the International Criminal Court. I was part of the Women's Caucus and one of its former directors. We attended the preparatory meetings, which was held both in New York and in The Hague, to learn what this international court is all about and how to put the crimes committed against women into its statutes. It was all a learning process for us. As we all know, the 1990s was a tumultuous year. It was the time when the comfort women in Asia came out to talk about sexual slavery 50 years later, the mass rape of women in former Yugoslavia, Bosnia-Herzegovina, the genocide in Rwanda, the Congo rape camps, the Sierra Leone bush marriages, the rape of women in Sudan and Somalia and other countries. No justice was ever rendered to the women victims and survivors of this sexual violence in situations of war and armed conflict. Why? Because it was not codified as a crime in international law. At the diplomatic conference for the establishment of the International Criminal Court in Rome in 1998, and that was way back, the Women's Caucus forced international law to recognize rape, sexual slavery, forced pregnancy, forced sterilization, and gender-based persecution as war crime and crime against humanity. I personally remember the moment when the word sexual slavery and sexual violence finally appeared in the official text. We all cried silently. We had done what generations before us only dreamed of. We had inscribed women's bodies, pain, and resistance into the permanent record of international law and introduced feminist jurisprudence. For those of us, and many of us, who have worked at the intersection of feminist activism and international law, which I have done for decades, we are now at another turning point that will shape women's agency for generations to come. The Crime Against Humanity Treaty will set the standard for prevention, prosecution, and state responsibility. Our challenge now, all of us, will be to prevent backsliding from the gains we made in Rome and to go further to ensure that crimes against women are codified into every article of this new Crime Against Humanity Treaty. It is for this reason that we are gathered here today, and I have to say, we have an excellent pool of speakers who are all dear friends of mine. We have all been here at the first preparatory meetings in New York, and they will discuss with us what the Crime Against Humanity Treaty is all about and what we can all do. So now I would like to start by asking our first speaker. Yeah. Tess Graham. Tess, she's a legal advisor of the Global Justice Center, where she works to advance gender justice in the Crime Against Humanity Treaty negotiations. She is also chairing the Gender Caucus, which we would meet once a month. I would just also want to mention that there is a Crime Against Humanity coalition that we have set up. There is a gender justice caucus that looks at the gender dimension of the treaty. And then we also have this new working group on crime against humanity. So all of these structures are very interrelated and will be working together with all of you. Now, Tess, can you give us a background on the development of the Crime Against Humanity Convention, the elements of the Crime Against Humanity, and the prosecutorial procedures at the international and national levels? You may now have the floor.
Thank you so much, Indai, and thank you to all of you for the opportunity to speak and join you and spread awareness of this treaty. So, as Indai mentioned, the Crimes Against Humanity Treaty is a continuation of the legacy of the Rome Statute and the ICC, as well as the tireless work of activists that brought that treaty into existence and that brought the recognition of international law to the crimes committed against primarily women and other gender-based violence across the past decades. This is our turn and our opportunity to carry forward that legacy. So I'll try to be brief and as non-legalistic as is possible, but we also really welcome questions at the end and intend to leave plenty of time for conversation. So the reason that we need a new treaty is that there is an existing gap in the international legal structure that has been put in place to protect against atrocity crimes. So certain crimes are considered so vast and of international concern that they reach the level of international crimes. This is usually when a crime is a part of not just individual perpetrators' actions, but a larger policy. These crimes include genocide, war crimes, aggression, and crimes against humanity. And we have treaties that govern the interstate responsibility, the intergovernmental responsibility to prevent and punish these kinds of grave crimes. We have the Genocide Convention that obligates states to prevent and punish the crime of genocide. We have the Geneva Conventions, which obligate states to prevent and punish war crimes. We also have the Rome Statute, as Indai laid out, which deals with individual criminal responsibility. So individual perpetrators are brought and prosecuted for war crimes, genocide, crimes against humanity, and potentially aggression. However, we don't have a treaty that is parallel to the Genocide Convention and the War Crimes Conventions, the Geneva Conventions, for crimes against humanity. And this is a big gap because crimes against humanity are sort of the catch-all crimes that cover a lot of the worst atrocities that individuals experience, but also that don't have a lot of the sort of more technical requirements of things like genocide and war crimes. And so if all you have is genocide and war crimes as legal categories, you're going to miss out on justice for a lot of the crimes that impact people on a daily basis. Crimes against humanity are defined as widespread or systematic attacks on civilians with the perpetrator's knowledge of the attack. The difference, as I mentioned, between ordinary crimes, so-called ordinary crimes, and international crimes is that scale, the widespread or systematic, as well as the fact that they need to be part of some kind of a policy, whether informal or formal, from a government, a non-state actor, or other authority. So all of this kind of background, these gaps in the international legal structure led to a move in the early 2000s or mid 2000s to try to codify crimes against humanity in the same way that we have treaties on the prevention and punishment of war crimes and genocide. There was a movement among civil society and academia to codify crimes against humanity. That led in 2019, eventually, to the International Law Commission, a UN body, to submit draft articles on crimes against humanity to the UN General Assembly, Sixth Committee. And eventually, after much discussion, those draft articles have now been forwarded from the Sixth Committee and brought into a specific time-bound process that will lead ultimately to the negotiation of a full convention and states being able to ratify that convention. So we're in the midst of that timeline now. And what's exciting about this moment is that we have the opportunity now to take those draft articles that have been submitted for consideration and have been accepted as the rough basis of the treaty. We have the opportunity as civil society to advocate for changes and advance our goals for the recognition and protection of gender-based violence within that treaty process. We saw part of the treaty process so far and part of the time-bound timeline that the General Assembly laid out is that we've had preparatory committees in January of this year, and we will have another preparatory committee in April of next year. And this is laying out sort of the groundwork and allowing states to voice their initial thoughts and opinions about the treaty. And then in 2028 and 2029, we'll have the actual negotiating conferences of the treaty, of the draft articles. This will be a process, as I said, until 2029, where we have opportunities to shape what is included in this treaty. And civil society has a really robust opportunity to be involved, including thanks to the decision by states in January of this year, which was shaped by a lot of civil society advocacy to allow for civil society involvement, including non-ECOSOC organizations. So organizations and individuals who don't have that rather bureaucratic status of ECOSOC accreditation. There is going to be a process for civil society to be involved. So I'm going to stop there and pass it on to my colleagues, but I look forward to more conversation about how we can make this, how we can seize this opportunity.
Thank you so much, Tess, for such a very good presentation on the background on the Crime Against Humanity Treaty. Now, we are definitely going to open the discussion to all our participants. So now I would like to call on to our next speaker, Susana Sakuto. She is the director of the War Crimes Research Office at the American University College of Law in Washington, D.C., where she also teaches international criminal law. Susana, can you please give us an overview of the proposed substantive and structural changes that would ensure the treaty is gender competent and progressive, including proposals on what is reproductive autonomy, slave trade, forced marriage, gender apartheid? Well, you may have the floor now, Susana. Thank you.
Thank you so much, Indai, and thank you for the invitation to be here with you today. I was just looking at the list of attendees. There are nearly 200 of you on this call, and I'm overwhelmed by just the introductions that people have put into the chat. So thank you to the members, to the leadership and the members of the NGO CSW Working Group for making time for this important conversation. It's really great to be here. As Tess said, I think that the draft Convention on Crimes Against Humanity is this first global treaty specifically dedicated to preventing and punishing crimes against humanity that fills this long-standing and very real gap in the international legal framework. But the question that Indai posed is, what needs to be done, right, to make sure this treaty is truly gender competent and progressive? And I think the draft treaty really offers us a rare opportunity to advance genuine gender competence and gender responsiveness. And I'm going to spend the next few minutes sort of laying out several significant ways in which it does this. The first relates to recognition of particular gender crimes or gender-based harms. As Tess said, the draft treaty uses the definition of crimes against humanity found in the Rome Statute that established the International Criminal Court back in 1998. So this treaty negotiating process provides us an important opportunity to update that definition to reflect the progress made in gender justice since that time. So a number of us have come together to propose changes to the draft treaty to make sure that it better captures how gender-based harms are understood and addressed today. So I'll give you some examples. International courts have already treated one of the crimes Indai mentioned, forced marriage, as a crime against humanity, even though it was not specifically included in the statute of the ICC or other international courts. And they did this by interpreting forced marriage as included within an existing crime against humanity of, quote, other inhumane acts. This treaty is a chance to make forced marriage explicit in the text rather than having to rely on interpretation, and that has several important benefits. It would help address concerns that some states raise about prosecuting crimes that are not clearly named and defined in their law at the time they were committed. It would reduce the risk that some national courts may interpret these harms as outside the scope of the existing treating language, and it would promote consistency across jurisdictions by aligning the law with existing international case law. A similar proposed amendment is to explicitly include the denial of reproductive autonomy. The current draft already includes what is called other forms of sexual violence of comparable gravity to the other crimes against humanity. But we know that reproductive violence, like the forced use of contraception, forced abortion, forced breastfeeding, denial of essential reproductive health care, that's distinct. That's distinct from sexual violence and should be recognized as such. So some of us have proposed that be included. Those are crimes that essentially have been recognized in jurisprudence of the international tribunals. We have an opportunity to do also something different, which is to recognize other serious harms that are not yet clearly established as crimes against humanity, but in our view should be, right? One of our speakers, Alyssa, will discuss this in more detail, but the End Gender Apartheid campaign and others have advocated for gender apartheid to be added to the list of acts recognized as crimes against humanity. Doing that would recognize that situations like that in Afghanistan today, where women and girls are systematically excluded from public life, from education, from employment, from basic freedoms, and they're excluded in a coordinated and sustained way, it would allow us to recognize that that constitutes institutionalized systemic oppression, domination, and exclusion based on gender and should be treated as a crime against humanity. The treaty is also an opportunity to include some other crimes, such as slave trade, starvation, environmental harm, that are not yet recognized as crimes against humanity, but really they reflect grave harms that almost always have deeply gendered impacts. Slave trade, for example, can involve the abduction, sale, or transfer of human beings, including situations where women and girls are placed into slavery by, for instance, being distributed to armed group soldiers for use as quote unquote wives. Starvation, as you well know, often has gender-specific effects, right? As women are more likely to eat less or least, and may be pushed into unsafe or exploitative situations simply to survive. Environmental harm, similarly, often disproportionately impacts women by undermining access to livelihoods, increasing economic insecurity, exposing women and girls to greater risks of displacement and violence. So explicitly recognizing these crimes would make these abuses more visible by clearly naming them in the treaty and helping to ensure that the lived experience of women and girls and other affected groups are fully acknowledged. And it would enable survivors to seek recognition and redress for those crimes. Another possibility that the treaty process, negotiation process gives us is a chance to make sure that the treaty includes ways of holding senior leaders responsible, especially those who allowed or enabled gender-based crimes, to be held responsible even if they were not directly involved or even far away from where the crimes happened. All of this is great, but of course those changes alone are not enough. We have seen time after time that even when the law is strong on paper, justice falters when no structural safeguards are in place to implement the law. So the other piece that some of us advocates have been pushing for in terms of amendments are structural provisions that will strengthen the likelihood that gender-based crimes will be properly investigated, prosecuted, and hopefully prevented, right? Some of us have advocated, for instance, that the treaty requires states to adopt laws and practices that fully criminalize and pursue gender-based crimes. But also more sort of structural pieces, right? To ensure that gender-trained investigators, prosecutors, and judges are among those responsible for investigating, prosecuting, and adjudicating crimes against humanity that involve gender-based violence. So that's one piece. The other piece, and this will be developed a little bit by our other panelist, Grant, is that to sustain sort of effective prevention, investigation, and punishment, we have also advocated for the adoption of a monitoring body capable of developing progressive interpretation of the treaty's provisions, particularly as sadly, new forms of gender-based crimes emerge. I noticed in the chat somebody talked about cybercrime. As these new forms of gender-based crimes develop, a monitoring body would be critical to interpret the treaty in gender-progressive ways. This treaty, like other treaties, will ultimately be the product of state negotiations. So who represents the state in those negotiations matter. So it will be critical for states to ensure that they have both gender parity and gender expertise on their teams, right? So the perspectives needed to shape a gender competent treaty are actually in the room during negotiations. Significantly, that will also require the participation of you, civil society, in both the negotiation and the implementation of the treaty, including civil society, survivor groups, experts, is really indispensable to helping ensure that the treaty reflects real world harms and diverse perspectives, particularly those of victims. Tess mentioned that we've advocated for an inclusive participation process during the negotiations, and we hope many of you will be engaged in that. And as Grant will elaborate on in a moment, civil society advocates from all regions, not just the West, will be critical for monitoring compliance, informing policy, ensuring prevention and accountability are really responsive to the needs and experiences of affected communities. I'll end with this. At core, this treaty matters for gender justice because it can bring together the lessons learned from international courts, national systems, and from practitioners like you. Your experience, your involvement can really help shape a treaty that makes sure gender-based crimes are not overlooked or misunderstood, and that states respond to them based on real knowledge, real experience, not bias or assumptions. Thanks so much. I'm going to give it back to Indai.
Thank you. Thank you so much, Susanna, for really walking us through what is the Crime Against Humanity Treaty and where we are at and what are the challenges and the issues that we have actually put forward here in New York. That's really very crucial for all of us who are listening right now, that these are very important long term in terms of what it will do once it's codified into the treaty. So thank you, Susanna. Now I would like to go to Alisa, yeah, our dear Alisa Yamamoto. She's a human rights lawyer who is currently serves as the legal advisor to the End of Gender Apartheid campaign. Yeah, so Alisa will really expound more on that. Now, Alisa, can you explain further what gender-based crimes are, how the draft articles of the treaty address gender and sexual violence, and how how it should be included in the architecture, in the crime against humanity architecture, ensuring that gender apartheid, reproductive violence, and ecocide are addressed. The floor is yours, Alisa.
Thank you, and thank you to Pamela, Rosa, and NGO CSW New York for convening this really important and timely meeting. I am just in awe of the expertise in this room and really looking forward to the Q&A. So hopefully not going to talk too long. So I wanted to speak on two issues. One is just taking a step back and talking about the overarching fight over gender, period, and the term gender and where we are in the treaty. And then I'll dive into that specific proposal that Endai mentioned, which is on gender apartheid, and in passing some of the other proposals for these new gender-based crimes. So on this first point, I just want to note for this group, right now, the draft Crimes Against Humanity Treaty does not define gender. And this is intentional. It was the direct result of a coordinated campaign by feminist and LGBTQI activists, because initially the International Law Commission just replicated and copied and pasted the Rome Statute definition. So that definition defines gender as the two sexes, male and female, within the context of society. And we all know this is a highly contested and criticized definition. It was a result of a very brutal negotiation process that I'm sure Endai and others here can share more about. But the hope right now at this stage is that leaving gender undefined can actually ensure an inclusive interpretation going forward, and also just flexibility, right? If you define it too early and too rigidly, we're going to be stuck in that definition. But having it undefined means, as international jurisprudence, as norms develop over time, we can interpret it accordingly. Unfortunately, and probably to no surprise to all of you in this room, at January's preparatory meeting for the treaty, we did see this issue resurface. And the politicization and polarization of gender that is so pervasive in the more political arenas of the UN, I will say they have finally infiltrated the legal discussions at the UN General Assembly Sixth Committee, the Legal Committee, to the point where the right-wing, CFAM's talking points were being regurgitated word for word by certain delegates in the room. So over that January session, we had about 20 states, largely from the Arab group, call for the reinsertion of a binary definition of gender, or for gender to just be replaced throughout with sex. Some states, I will say, some states, to their credit, did try to defend an inclusive understanding of gender and the omission of the definition. But on the whole, this defense was really weak. And I frankly think that's because, unlike the opposition, not everybody was prepared for the attack and had a coordinated strategy for response. So I do think in this coming year ahead, it will be vital for all of you in this room, for civil society, to really coordinate a strategy with like-minded delegations in New York, but also their counterparts across capitals, to ensure the treaty remains gender inclusive. And I really hope in the Q&A, part of this can be learning from you all, from your advocacy at CSW 70, from your advocacy across the UN and multilateral system. What does it take to counteract this force, this regressive force? And some of this will be, I think, thinking about counter narratives that stick, particularly in pushing back against the argument that the term gender is too vague, or that SOGI, is a Western construction and expert, which we all know is not true. So again, would really benefit from the expertise here. Of course, we can't just focus on the definition of gender. So I do want to just underscore, we need a comprehensive, robust, and principled strategy on gender, one that's not just defensive and protective of the hard-fought gains that feminists have made to date, including in the Rome Statute, but that goes further. One that actually progressively develops the law to reflect the lived experiences of victims and survivors today. The breadth of gender-based harms being perpetrated now, and even trying to predict, right, what will happen tomorrow. We need to future-proof this treaty to make sure it actually remains relevant and useful to all of you, 25, 50 years from now. So I do want to turn to one of those proposals to future-proof the treaty, if you will, which is the proposal to codify gender apartheid. And this is, as others have mentioned, this is largely animated by the situation in Afghanistan. And it really is, I want to underscore, led and driven by a coalition of Afghan activists. I am just here merely as, a legal expert that provides assistance, but the strategy and all of the movement building has been led by our Afghan counterparts. So just a quick overview of the factual situation to concretize the proposal. Since August 2021, the Taliban takeover, they have issued and violently enforced over 200 decrees, laws, and edicts that directly target women, girls, and LGBTQI individuals. I think many here are familiar with the ban on girls' education after grade 6. But women are also prohibited by law from showing their faces outside of their homes, including from even being visible through windows into their homes. They're prohibited from singing, from reciting or reading aloud in public, from traveling anywhere without a male guardian, including to try to access your reproductive health care and your other essential healthcare needs, from working in most sectors, and the most recent January Penal Code legally recognizes slavery and sanctions domestic violence unless your bones are broken or your wounds are open. So this is gender apartheid. This, I think many people will hear what is happening and kind of intuit. There is something so totalizing, institutionalized, and deliberate about this architecture of systematic gender subjugation that is distinct. It's very distinct from, your everyday gender discrimination that I think many of us, exist under in our own societies. So right now, though, there isn't a crime against humanity that captures that institutionalization of gender oppression, or the dystopian vision and intent to maintain a regime that is rooted in the systematic subjugation of women, girls, and LGBTQI individuals. So the End Gender Apartheid campaign is really trying to make this decades-long call, actually, for recognition of gender apartheid, including by Afghan feminists back in the 1990s, right? Make this finally a legal reality. So just to close, I want to say why is codification important? Why is it important to actually legally recognize something like gender apartheid? And it's really simple, and I think, Endai, you opened with this, right? You cannot prevent or punish what you do not name. And I'll just note that the current situation in Afghanistan is actually emblematic of the suite of gender justice proposals on the table for the treaty. So the slave trade, reproductive violence, forced marriage, all of these are being perpetrated by the Taliban today. And I think really make clear to us and concretize to us why we are in this fight. Each of these crimes are enumerated, even when they might involve some of the same underlying facts. And that's because reparative justice requires us to recognize the full scope of harms that are being caused, right? There's a reason we prosecute the crimes of rape, of forced pregnancy, forced marriage, even if they might involve the same underlying acts of sexual violence. And that's because the elements of these crimes protect distinct interests. It's our sexual autonomy, our reproductive autonomy, our relational autonomy. Each of these deserves and must be named. And we think the same is true with gender apartheid. We have gender persecution, but we don't have anything to cover this institutionalization and intent, which is why we are asking for gender apartheid. So I'll close just to say, we really do see Afghanistan as a test case for the international community, for civil society, especially as we're seeing this backsliding on gender equality across the globe. We all know what silence and inaction in the face of these atrocities is. It's a green light. It's a green light for future regimes. So if we don't criminalize and name these harms now, we can only imagine how much worse things will be going forward, and also how much they will spread borders. They will spread across regions. So I will stop there, but I'm really looking forward to our discussion and just brainstorming strategies going forward. Thank you.
Yeah. Oh, thank you so much, Alyssa. I mean, it's just so important that we are at this point in time recognizing the term gender apartheid. It's a new crime. It's not new. That crime has been committed to women for centuries. The targeting of women on the basis of their gender and making laws, in relation to subjugate women. So yes, I mean, these are some of the things that we will further talk about. And as you were saying, and Susanna was saying, there are new crimes out there that we need to talk about as well. So now I would like to ask our next speaker and our last speaker, Grant, Grant is an international human rights lawyer focusing on mass atrocities, and he is also the senior legal advisor at the Danish Institute Against Torture. And I would have to say, and I was always told I should say, that one is one of our few guys in our team, or one of our many guys, who is really a feminist. You know, he's always, fighting out there for our issues. So yes, thank you, Grant. Now, Grant, your expertise is in monitoring the importance of treaty development framework, covering the sessions and lobbying governments that support or do not support the articles in the treaty. Can you share with us the recent PrepCom in January? You can name the governments, the good governments and the not so good, who are supporting our issues and why they are not supporting. And can you also tell us about the victim support structure that we are advocating? The floor is yours, Grant.
Sure, thank you. And thank you for the kind words. And it's really an honor to be here. Thank you to the NGO CSW and to my co-panelists as well. You know, I come to you all from Eastern Canada in what has finally arrived as spring here. So it's finally I can rejoice a little bit. With respect to covering the PrepCom, to be frank, I would really defer to colleagues who are physically present, and I was not physically present there. But I will, if useful, I can talk about the importance of monitoring and having infrastructure and machinery to ensure monitoring in the treaty moving forward. And I would point to you, Alyssa or Tess or Susanna, as to the PrepCom. So I will try to be very, very brief. So because I think maybe the most important thing to do at the end of this conversation is know who to focus our energies on and how to focus our energies. So but just a brief little bit on a more formalized architecture for monitoring in the treaty, because I do think from a feminist perspective, it's very, very important. And part of the reason why I say that is, the treaty, the draft treaty, it's groundbreaking. It's extremely important. It's all the things my colleagues have said. It's also, the draft version is 15 articles long and is about 9 pages. I think it just goes over 10 pages. That's not a big document. For us lawyers, that's a very, very short and small document. And the only provision it includes that is intended to ensure compliance with the treaty, to make sure that states parties actually adhere to their obligations, the international legal obligations they take on by being parties to the treaty, is state-to-state dispute resolution. Essentially, one state suing another state in The Hague at the World Court, arguing a violation of the treaty. That is an exceedingly rare occurrence. Lots of treaties have that provision. Very few of those cases move forward. For those of you who really, really follow, there's maybe an increasing trend, but it is nevertheless an extremely rare thing to happen in our world. And what that means is that really the only opportunity for states to be held accountable for failing to implement their obligations to prevent or punish crimes against humanity relies on a state having the political will, the resources, and the conviction to actually initiate such a case at the World Court. And that's not going to be good enough. If from any advocate's perspective, not least of all a feminist perspective. One of the other reasons I really want to highlight is that even assuming that one of these cases did move forward, there is no formal avenue for civil society, for victims, for survivors, for representatives of those groups to engage in those lawsuits, to engage at the World Court. There's nothing at all. It is purely state to state. And so that really leaves advocates like yourselves and other gender activists with very, very limited opportunities to ensure the progressive interpretation of the treaty. I can say a lot more about why I think there should be a monitoring mechanism, but in the interest of time, I won't. And instead, what I'll do is highlight what I think a monitoring mechanism in this treaty should do. And for the past 75 years, treaties in international humanitarian law, which is relating to armed conflict, in international humanitarian law, armed conflict, human rights law, or criminal law, and even transnational treaties relating to crime, they have all included one or more monitoring bodies or secretariats that are dedicated to making sure that states implement and actually perform their legal obligations. And these different bodies can take different forms. One of the most important ones, and Susanna, you mentioned this, is issuing interpretation and guidance of what the terms of the treaty actually mean. And so you need a central body to provide a coherent interpretation for effective implementation of the treaties. And across, the recent, 40, 50 years, we have seen that international courts, like the International Criminal Court, or like the International Criminal Tribunal for the former Yugoslavia, or the International Criminal Tribunal for Rwanda, when they were adjudicating their cases on sexual violence, when they were doing their groundbreaking cases on rape as torture or as rape as genocide, they relied on these interpretive bodies from treaties, on the treaty monitoring bodies, the Committee Against Torture, the Human Rights Committee, the Committee on the Elimination of Discrimination Against Women. The interpretive and authoritative guidance that came out of these monitoring bodies holds significant weight for the determination of what these crimes look like. So courts can say, well, yes, rape is torture because what these the Committee Against Torture has said so, and we know that it creates this type of suffering. And so it's extremely important that there's a centralized body providing these interpretations moving forward. And that's not the treaty bodies can do this in any number of ways, including through issuing general comments or general recommendations, by issuing concluding observations in periodic monitoring, or just generally issuing other recommendations. So interpretive guidance is an extremely important one, but also very, very important is capacity building, is creating a mechanism for technical assistance and international coordination. And Suzanne, I hate to keep leaning on you, but another thing you mentioned is that it's really important that there is gender competence in the investigation of crimes against humanity, that people who are going to be prosecuting, or the judges who will be adjudicating, or the people investigating or providing reparations for, they know what gender harms look like. They know how to interview people who have experienced gender-based violence. They know the particular sensitivities to approaching LGBTQ communities, or what have you. It is extremely important that this gender competence is at the ground level for the folks that are going to be performing the obligations under this treaty. And that is a very technical thing. There are people who have years and years and years and decades of expertise on interviewing survivors of sexual and gender-based violence, or of facilitating reparations for survivors of sexual and gender-based violence. That knowledge sits somewhere in the world. It doesn't sit everywhere in the world. And so there needs to be a treaty body, a mechanism, some sort of infrastructure built into this treaty to make sure of a knowledge sharing, to make sure that there's capacity building, that there's technical assistance, such that in places in the world where there needs to be more capacity development, there's a clearinghouse, there's an area where that knowledge can either be created and generated, or where states can discuss mechanisms to share some of that information. Thirdly, and one that maybe you all are familiar with, is the process of periodic monitoring or reviewing of state compliance. So these are things like treaty monitoring reviews, or bodies not dissimilar from the Universal Periodic Review, but under the branch of the treaty. This happens at it's very difficult to not use acronyms. The International Covenant on Civil and Political Rights, on the Convention Against Torture, on the Convention on the Elimination of Discrimination Against Women, on any on all human rights treaties, there is a process where states are periodically monitored for how they're doing and implementing the terms of the treaty. It starts with the state writing a report to the treaty body sitting in Geneva. The treaty body analyzes that report. There's input from civil society on whether or not the state is being honest, or what the state might have left out. And then the reviewing body issues concluding observations. That is a very typical mechanism in a human rights treaty that isn't in this one, that does create a really robust architecture for civil society to be involved. And finally, the last thing that I want to mention is opportunity for receiving communications or issuing determinations as to the occurrence or the character of crimes against humanity. This is another feature that you see in other human rights treaties. For example, the Convention Against Torture has Article 20 that says, when the committee receives information that there are systematic violations of the convention, the committee in its own authority can undertake a review to understand, the depth of the problem in that particular country. There's also, of course, individual complaints, depending on which treaty you're talking about. It looks different, but there's a way for the treaty body to receive complaints and adjudicate complaints. That is essentially a version of a wish list. Now, and it would be the treaty monitoring body to issue interpretive guidance, to facilitate capacity building, to do periodic monitoring, and to make issue determinations or adjudicate individual complaints. There are pros and cons to each of those, some politically, some practically, some pragmatically, but the overall point is that it is extraordinarily important for there to be some architecture that ensures that the treaty isn't just a static piece of paper, but that is a dynamic instrument that ensures that the gender protections that my colleagues have talked about are actually implemented and made material as countries carry out their obligations. I hope I haven't gone too long, but I don't want to forget. And you had asked me to answer something very, very different, so I do defer to my colleagues on the PrepCom and which countries are allies and which countries maybe needs to be the focus of more advocacy. Yeah. And I also will end with, the irony is not lost on me that being the only male on the panel, I did not ask the question and I just said what I wanted to say, which has very terrible gender undertones. So I'm sorry for that, but I wouldn't have not have given you an adequate answer. So please, colleagues who follow the PrepCom, please answer that question for me.
No, oh, thank you so much, Grant. You were perfect. Okay, you were perfect because you really deconstruct what Tess and Alisa and Susanna have put forward. Actually, it was much better answer than my question. And the reason for that is you really look at the monitoring mechanism, the importance of what Susanna was saying, why gender competence within these statutes of the new crime against humanity treaty is very important, because we are not just putting the crimes out there to be codified, but we want to make sure that the procedural and administrative structure is in place to support it. And you explained that excellently, because that is exactly the structure that we want to know, how this is also interrelated to the other treaties and to the other international courts and the 6 committees and all the conventions like torture are so interrelated and complementary. But of course, we need to move forward beyond what was codified before and to really make it better. So yes, thank you so much. That was excellent, Grant. Now, I would like to ask, maybe before we open the question, just quickly, maybe for Tess and Susanna and Alisa, just to talk about how the governments conducted themselves at the preparatory meeting in January here in New York. We were all there. And can you just say which government is good and not so good and the bad ones? We can start with Tess, Alisa, and then Susanna. And then we will wait for the question from our participants.
Yeah. Thank you so much. Yes. I'm not sure I can tell you which governments are good and not good. That's a question above my pay grade. But I can tell you a little bit about how those dynamics played out. And just zooming out, I think we've now sort of tried to emphasize amongst all the panelists both why this treaty is so important and also what we would like to see. So, we have the draft articles. It's important that the draft articles move forward. But as they are right now, they're nice, but they're not perfect. So we would like to see some changes. And we've seen that we have government allies on each of these points. We have some governments who are really committed to moving the treaty forward overall. But most importantly, we have some government allies who are committed to advancing the gender justice opportunities that this treaty represents. I'll say that we have, throughout my work with the Global Justice Center, seen really amazing feminist advocacy organizing around the treaty, and feminists have been at the center of civil society advocacy overall on the treaty. And so it puts us in a really good position, I think, to have an influence on governments. That being said, it has also generated some resistance, as Elisa was describing. There were governments, including especially in January at the first PrepCom, who really have gotten organized and been working together to instrumentalize and weaponize the concept of gender in a way that we're all very familiar with, I think, and that we need a strategy, a coordinated strategy with all of your help to counter. So getting specific, we saw continued leadership from some really important governments that have been leading the charge throughout this process since the draft articles came to the UN Legal Committee. And that's from Mexico and the Gambia in particular. The Gambia has, both of these countries have wonderful women legal advisors who are championing the need for the treaty and the need for feminist and gender justice conscious changes to the draft articles. We saw important contributions from Sierra Leone and the Philippines, Colombia, Costa Rica. Palestine has been an incredible leader on the treaty overall and on ensuring that our understandings of what gender justice looks like are infused with an intersectional lens that includes colonialism and racial apartheid. Brazil, I see a mention of Brazil. Brazil has been an ally. We would love to see more from Brazil. We would like to see a lot more from Brazil. And I'll say that there are a number of states that we see as great allies or great potential allies who have not maybe stepped into their power as much as we would like. And that's where we need all of you to urge your governments to step into their power. I think that having us in New York talk to the governments, very limited efficacy at the end of the day because they need to hear it from their capital, their political leadership. Well, I won't say very little efficacy because we've had some impact, but but they really need to hear this from the people who are at home, including the civil society that they face every day. So I just want to also shout out a few more positive states. Lebanon has been mixed. I think that's another one where we could use a lot more civil society pressure. Iceland, Ireland, Portugal, Spain, France, the UK, and Canada have always been reliable allies for us. And also want to mention a few of the problematic states, as might not be a surprise. Russia, Iran has been challenging, and Russia and Iran really worked together in January to weaponize the concept of gender, along with, as Elisa mentioned, a coalition of states that came out with a really regressive statement about the definition of gender that included Iraq, Algeria, Bahrain, Egypt, the Islamic Republic of Iran, Jordan, Kuwait, Libya, Oman, Pakistan, Qatar, Saudi Arabia, Sudan, Syria, Tunisia, and Yemen. We also have seen a lot of pushback from Nigeria on the overall concept of having civil society be involved. And Argentina has been a very unfortunate reversal as we saw political fortunes there change. So they've been really negative on gender in the last few interventions. So that's a little bit of the flavor. If you want to connect on your particular state, please reach out to us because we would love to strategize and provide any support we can in terms of coordinating that advocacy on the domestic level, because that's really where these states are going to be making a lot of the decisions, not in New York. They'll be making them at home.
Yeah.
Alisa?
Okay. Alisa, please. You're muted. You're muted. Yeah.
Oh, can you hear me?
Yes.
I think Tess covered a pretty broad landscape. I mean, one thing I'll flag is that group of states, and I just put in the chat this regressive statement on gender that came out at the really 11th hour of the session. Interestingly, they were not able to actually get a formal Arab group statement, right? So that's the silver lining. Same with some of the African group, right? There was very regressive statements from Burundi, Cameroon, Namibia. Again, I think there were some efforts and behind the scenes mobilizing to try to get formal regional group statements. And the fact that they were not able to get there yet, I will say yet, is at least a silver lining that there wasn't the sufficient consensus to put that forward. Even among those that signed the Iraq statement, we know, for instance, Tunisia, which is actually usually quite positive on gender equality and gender issues, we were told pretty bluntly, you know, their sixth committee never consulted their third committee expert who covers human rights and gender. So this is also the work that would really benefit from, I think, this group's expertise. Many of you I know from CSW, from other engagements with the UN system, are very close with, you know, the core groups on gender and LGBTI in the third committee or the Human Rights Council or women, peace and security experts. Like, all of those experts need to be aware of this treaty and be nudging their legal counterparts to actually take a gender competent approach to this treaty. We're very concerned that a lot of these legal advisors are working in silos, frankly, and not really privy or like not caring, frankly, what their counterparts who focus on gender would say to these issues. The two other things I would flag, South Africa, they were actually the civil society coordinator to try to decide on the potential inclusion of civil society going forward, which did land at the positive place that we mentioned earlier of non-ECOSOC organizations being able to participate at the diplomatic conference. And I should clarify that actually means for the second preparatory committee session, you will still require ECOSOC accreditation. And our hope is that we can, you know, pool our ECOSOC passes with many people here to bring as many survivors and affected communities into the room and actually give that direct access on the treaty discussions. South Africa, though, is very positive on gender issues, and I think is a really important player in the African group in dissenting from a pretty regressive backsliding. So I would really encourage engagement with their government. And then I'll just flag maybe two more things. The US government, the elephant in the room, right? So they were silent the whole time. They did attend, but they did not really speak or engage. I'm going to assume that's going to change by the second preparatory session. So we need to be at the ready. And I think, again, to this point of not being reactive, but thinking what our overarching proactive strategy is, we need to be prepared. And the last thing I will say is there's the Feminist Foreign Policy Conference coming up in June. I assume many people here will be there. I will be there speaking on a panel on gender apartheid. We'd love to try to get that group of states really activated on the treaty. Many of them, you know, they're ministers of women or gender equality who go to these types of feminist foreign policy convenings are not really aware of the legal discussions on the treaty. So again, helping us triangulate is really essential, I think, going forward on our strategy. I'll stop there.
Thank you, Alisa. Susanna?
Yeah, thanks so much. I think Tess and Alyssa really covered the ground. I think the only thing I would love to know from you all is maybe practice or laws that are already either being advocated for or exist in your countries that deal with the issues that we've been talking about: reproductive violence, gender apartheid, any of these topics, because your experience, your practice, your laws may help us further the discussion with states that are now considering the treaty and considering their position on the treaty. So it'd be really interesting to learn from you, you know, what is happening in your own jurisdictions that relate to these areas. So I'm going to stop there and really kick it over to Q&A.
Yes, okay. Thank you so much, Susanna, Tess, and Alisa. Grant, any last words? Okay, thank you. We would like now to open the floor for any questions.
And
Yes.
before we open the floor, I just want to make two short statements.
Yes.
The first is I want to, well, before the two statements, I want to thank this incredible committee, this incredible panel for this insightful discussion. You can see from the chat that our members are just really overwhelmed. And Rosa is going to go into more detail when she convenes the Q&A. But two things. Tess put a link in the chat to a website, and I want our members to be sure to look at the declaration. It's Advancing Gender Justice and the Crimes Against Humanity Convention, and there are over 235 endorsements. And I think this is important. I think that our members need to take this back to their organizations so that their organizations also understand. And my second point is that NGO CSW will be convening a working group on the crimes against humanity, and the first meeting will be the end of June. We're waiting for word from one of the member states who indicated that they would like to speak at the meeting. So we're going to have a convening the end of June where we open a crimes against humanity working group that looks at gender. It's going to be specific to women's issues. And with that, I'm going to turn the microphone over to Rosa Lizardi, my co-chair, to moderate the Q&A. Thank you.
Thank you.
Thank you so much, Pamela, and thank you, Ndai. We have about, let's say, 10 to 12 minutes for the Q&A. And I know that there were some questions in the chat. I'm just taking one by Gail James. Are you integrating CEDAW mechanisms into this new process and work? I think that there's been some mention of that already, but just specifically, maybe someone can take that one. And I want to open up. We have 3 people that I see here with questions, and I'm asking that you limit your question to 30 seconds to 1 minute only, so that we can have time for our wonderful panel to answer them. So Linda McDonald, please unmute. Yeah, thank you.
Thank you very much. This has been tremendous. I'm Linda McDonald from Nova Scotia, Canada. I'm a feminist activist working with women who've been tortured by non-state actors or non-state torture. And I'm wondering how non-state torture can be included as one of the distinct crimes in the crimes against humanity, especially because of their global context around criminal and informal networks. And we see that with the Epstein case. Many of the women that we work with have been tortured in criminal informal networks such as this, from infancy through human trafficking, pornography, prostitution, migrant women. So I'm interested in your understanding or support of non-state torture or torture by non-state actors. Thank you very much.
Thank you so much, Linda, for the question and the work that you do. Mia Yi, please.
Hi, thank you so much. This is a question directly to Alyssa. I would like to know, from your incredible work, I've heard there's the women in Global South, they are not allowed to go out in a certain way and second citizens and etc. I'm a transcultural nurse and a nurse practitioner. I would like to understand, this is over 2,000, 3,000, 10,000 years old history and culture. What is your insight or input of the cultural change within?
Thank you so much, Mia Yi. Shaila?
Thank you for the excellent presentations. I'm Shaila Rao Mistry, CEO, founder of STEM Institute, and Vice President of U.S. Women's Caucus. My question is for all speakers, whoever can answer, on the cyber crimes and harm that is extreme harm that is being done to women, the deep fakes, the harassment, the digital abuse that's happening to women. It's real. It's a silent crime. How is the treaty addressing that? Has it been included in language, monitoring, etc.? Thank you.
Thank you, Shaila. Very nice to see you.
Good
Let's
to
just
see you.
take Nandigo, Kathy Nandigo, and we'll do this first round, and see if we come up with more questions. Kathy? Okay, Kathy has disappeared off our screen. So hope everything is okay there. Let me turn to our panel. And I know there was a question specifically for Alyssa. Maybe we can start with you. And then there was a question about non-state torture. I know that maybe some of you are replying also in the chat. And Shila's question about cyber crimes. Alyssa?
Sure. And I hope I understood the question correctly, which is really the cultural roots of, and I couldn't tell if you're going in the direction of this type of misogyny and kind of ingrained patriarchal structure, or if you're going in the opposite direction of the cultural transformation and kind of resistance internally. Maybe, I don't know if, just to clarify.
I would like to know your insight and input. This culture has been existing for thousands of years. And from the Western point of view, yes, this is A, B, and C. But from the culture itself, it is a living culture. So how do we move or transform?
Yeah, I mean, I think this is one of the real challenges we struggled with, not just on the gender apartheid work, but more broadly on this gender justice fight, right? Is what is cultural, what is an import or export of colonialism, et cetera. I will say on the cultural points for gender apartheid, I actually think there's a lot of misapprehension or misunderstanding in the global community as to the roots of the Taliban's gender subjugation and this structure. And in fact, a lot of it can be traced to the Soviet invasion, kind of the post-imperial period in Afghanistan, and what was in fact a much maybe more freer, as we understand, a society that predated that. And we get often this critique that, well, that the Taliban are actually freedom fighters and indigenous, right? And this is reflective of the root, a broader cultural norm. But I would start, very much disagree with that assessment. And maybe also just make the point, obviously, international law is clear, cultural or religious pretext. None of this can justify these types of gross violations of international law, international criminal law, human rights law. On the idea of gender more broadly, I also would love to flag, and actually this is something we're exploring and very interested in, how we understand a more inclusive interpretation of gender as being rooted in kind of a post-colonial critique, and actually tracing back the roots of pre-colonial times in a lot of these regions. You actually see, again, a much more fluid, inclusive interpretation of gender that then becomes more binary through the assertion of power and kind of the asymmetries of power by colonial and imperial forces. And again, this I think goes to the narrative of kind of figuring out the counter narrative that sticks against this idea of it being a Western expert. And I might just share in the chat a really interesting report by the independent expert on SOGI on this issue, the former one. It might be of interest to this group and resonate.
Thank you so much, Alyssa. And thanks for those comments also, Tess, and others in the chat. Susanna, do you want to take the question on? Okay. Linda's question.
Yeah, I'm happy to. Yeah, thank you so much. Maybe I'll try the non-state actors and the cybercrime question really briefly, although of course others can complement. I think it was Linda who talked about torture by non-state actors, and the answer with respect to crimes against humanity is that it can apply to both state and non-state actors. There is no requirement that any accused person accused of crimes against humanity be a state actor. The real requirement is that the conduct meets the elements of crimes against humanity, what Tess said, widespread or systematic attack against a civilian population, and that the conduct was conduct like sexual violence or gender one of those things that is included as an act that is then connected to that widespread or systematic attack against the civilian population. So the focus is on the elements of the crime. Every crime against humanity case piece has two parts. One is the substantive part, and one is how do you attach liability to the particular accused that's on trial, right? And so if they directly participated, that's easy. But sometimes who we have on trial are leaders who are not actually committing the crime or or present even at the time of the crime, but they still can be held responsible if they ordered it, if they were complicit with it, if they joined with other people in a joint criminal enterprise to make it happen. So there are different ways to attach liability to both state and non-state actors. And sometimes it's hard, maybe a little more challenging with non-state actors, but it is possible and has been done. I think the question on cyber crimes is a really good question. It's not specifically included either in the draft articles or, frankly, in some of the proposals that I spoke about thus far. It can be included, for instance, as the crime against humanity of persecution, right? So persecution is really about the deprivation of fundamental rights on the basis of a group category like gender, right? And so it could be argued that way. It's an interesting, I think, piece for us to take back and think about whether or not we should actually put on the table cyber crimes as a proposal. But one of the things Grant mentioned that is going to be super critical is if we don't have agreement by states to include cyber crimes, we at least need a monitoring body that can interpret persecution or other acts as encompassing cyber crimes, right? So the conduct of violating people's rights on the basis of gender to persecute a category like women or girls can be interpreted as persecution, but it requires that work. It requires that interpretive work. So the monitoring mechanism that Grant talked about would be critical. And maybe since he has his hand up, I'll shoot it over to him.
Great. And I want to leave time for Tess and I to bring closing remarks. So if we can limit to 1 minute, thank you so much.
Of course. Well, firstly, I wanted to say thank you for your question, Linda, and happy to offer a very small response because Susanna covered it, but speaking from a basement in a museum in Lunenburg County, Nova Scotia. So funny coincidence there. Answering both the cyber question and the non-state actor question, the one unique element of torture as crimes against humanity is custody or control. So whereas in human rights, it's state actor, for crimes against humanity, it's custody or control. And my work in Dignity, I'm actually exploring trying to articulate certain forms of cyber violence as exerting a type of custody or control over a person's life. Custody or control is not interpreted as imprisonment. So this is some work I'm doing. It will be published later on in the year. But overall, I wanted to highlight the point that the cyber stuff could be included not only in persecution, potentially other inhumane acts or torture as well. But highlighting Susanna's point, the only way that can be possible is if there's interpretive guidance being offered by a treaty monitoring body. So sorry to repeat what you said, Susanna. I just wanted to add that small caveat.
Thank you so
Can I just
much, Brent.
very quickly say that one of the proposals we have is to take the custody or control, remove that from the definition of torture. So that's an alternative way. Sorry, go ahead.
Thank you so much, Tess, and then Endai to close us out.
Yeah, thank you so much. I'll try to be brief as well. And I would love to, if Nandego, Kathy wants to connect with us via email to ask questions, happy to do that. I just wanted to come in quickly on the point about culture and say that I think that another really important aspect that we want to highlight is that in the specific case on gender apartheid, the call for the codification and the recognition of this system of governance as a crime is coming from inside Afghanistan, from inside this culture by the people who are being victimized by it. And I think that when we think about cultural explanations for structures that are fundamentally oppressive, we need to really look at whose perspective are we taking and whose culture are we taking for granted and for whom is culture an excuse. And the analogy I actually draw on here is you could say that in 1815 in the US, throughout the US, but especially in the US South, there was a culture of slavery. But that was not a sufficient explanation for why this structure should be allowed to continue. It was a structure of oppression and violence, and it was critiqued from inside and outside and ultimately ended. With caveats on that as well, of course. So I just think that when we're thinking about culture, we can look at who are we listening to, and what kind of cultural explanations get credence and which ones don't. Just quickly
Great.
also to say that I don't want there to be confusion between war crimes and crimes against humanity. Things can be both war crimes and crimes against humanity, but the key difference is whether there's an armed conflict going on. And the great thing about having a crimes against humanity treaty is you don't have to prove there's an armed conflict in order to bring justice to survivors of atrocity. Thank you.
Fantastic. Thank you so much. And thank you for coordinating this panel. Fantastic panel, lots of interest, so important.
Yeah.
Can you close us out, please?
Thank you so much, Pamela and Rosa. I would just really for organizing the working group on Crime Against Humanity Treaty. And for all of us here now listening, this is a very important juncture for all of us feminist activists on the drafting of this new Crime Against Humanity Treaty. We need you all to work with us in putting your government to task of their accountability to ensure that these gender-based crimes are codified within the Crime Against Humanity Treaty. Why? Because it will be the next generation who will really pick on this treaty and bring the cases to court. As Thea, Susanna, Alisa, and Grant were saying, we have the challenge before us. And, this will go on till 2028 to 29. So we have 4 years to ensure that the struggles we have on the ground be elevated within the structure of the international of this international convention. And more importantly, remember the crime against humanity does not have to be committed during wartime, as Tess said. It can be committed during peacetime. Only we need to define the widespread and systematic. So we will need to work with you, work with your foreign ministry. We do letters, we send petitions, and all kinds of campaign advocacy work, which we'll be doing in the coming months, and which we will be facilitating through the NGO CSW working group. So I'll end with that because I know we have passed the time. But again, thank you, Rosa and Pamela, for facilitating this. And for all of you who are listening, let's move forward. Thank you.
Thank you so much. Let's show some love to our panel. I know you've already been showing your reactions, but this is such an important issue. Let's show some love to them all. Fantastic. Thank you so much. We are going to close out. I just want to mention that our next monthly meeting is June 16th, Tuesday, 11 a.m. Eastern. So please join. The topic will be access to justice, youth perspective. So we hope that you're able to join as well before we take a break in the summer. That's going to be our last monthly meeting for this CSW 70 cycle. So we're going to close out with our slogan, which is equality, peace, justice. I'm going to ask to open up to everyone. Open your cameras. This is how we close.
Yes.
We're going to do our slogan, and then we're going to say goodbye in your own language. So open
your audio. Get off mute, turn off mute. We want to hear every voice.
Bye.
So,
Bye. Thank you so much.
Equality.
Thank you.
Thank you so
Justice,
much.
When do we want it?
Now.
Now. We want
equality, peace, justice. When do we want it?
Justice.
Now.
Thank you,
Now.
everyone. Adios.
Adios.
Goodbye in your language.
Bye.
Ciao.
Bye from Trinidad.
Good seeing you.
Bye-bye.
Desde Bolivia.
Bye from California.